name is Marci Berger, and I'm the Member Services Coordinator at AFSA. Welcome to the Impact of State Address Confidentiality Programs on Extending and Servicing Credit, presented by Patty Covington and Marci Kawski. This presentation is a part of AFSA's Business Partner Webinar Series, which allows industry experts to share timely educational topics directly with AFSA members. The webinars are designed to provide information that allow AFSA members to more effectively design, develop, and implement strategies for their company's success. For more information about the series or how to become a presenter, feel free to reach out to me following today's webinar. A few housekeeping notes. To ask a question, use the question box on the side of your screen. The slides and recording of today's webinar will be available on AFSA's website in the Webinar Resource Center. Finally, you'll receive a survey after the webinar is over. Please take a moment to complete it. Your responses help us fine-tune the program so we can target the issues that are important to you. A bit about our presenters. Patty is a partner at Hudson in its Virginia office. She works with all types of consumer financial service companies, as well as other stakeholders in the industry, from platform, DMS, and ancillary product providers to auto dealers and retail sellers. She advises clients on a wide range of federal and state laws and compliance issues, including CFPB readiness and matters involving the Federal Trade Commission. She's been practicing for over 27 plus years, and prior to joining Hudson Cook, she served as Deputy General Counsel for CarMax. Marci is a partner at Husch Blackwell, a full-service law firm with 18 offices across the nation. Marci in the firm's Madison, Wisconsin office. Her entire legal career has been devoted to counseling providers of consumer financial services, including installment loan companies, motor vehicle finance companies, and banks throughout the country. She develops proactive compliance policies, procedures and strategies, consults on complex compliance questions, negotiates before state and federal regulatory agencies, and presents clients in individual and class claims. Now I'll pass it over to you, Danielle.
Thanks so much, Marci. I really appreciate it. We first started talking about this issue about 18 months ago, and we originally scheduled this webinar for about 10 and a half months ago. When we first started working on this issue, the concept of safe at home and being safe at home had a very different meaning than what it means to us today. This is a tough issue. These are, real people, and some of these people who are behind the development of these laws are people who've been in horrific danger from a stalker or an abuser. And AFSA, can't and won't stand up and say that these laws aren't important. And yet we know that there's a lot of unintended consequences that can make dealing with these laws really difficult as creditors. And that's why we knew we were picking the absolute right people to think about the tough parts of these laws and explain to everybody how to address them when we approach Patty Covington and Marci Kawski. Thank you so much, you guys, for joining us. I can't wait to hear what you have to say. And as Marci said at the end, as the other Marci said at the end, we will go ahead and take your questions. Go ahead and send your questions also in the chat.
Great. Thanks so much to Danielle and Marci for arranging this webinar and asking us to speak on the topic. As they do with so many issues that are important to the industry, Danielle and her team have been tracking this issue very closely that we're going to be discussing today. So thank you. Very good. So this is Patty, and we would not be very good lawyers if we did not give you a disclaimer at the beginning of our presentation. And so our presentation, we're providing it for informational purposes only. It is not legal advice, and it is not, these are Marci and I's views, so they're not to be construed as the views from our firms, Hudson Cook and Husch Blackwell. So, of course, we're always available to answer questions and happy to share information. So what are address confidentiality programs anyway? Well, they're programs that are designed to protect victims of, as Danielle pointed out, domestic abuse, violence, sexual assault, human trafficking, and those, again, horrific instances when people have been abused and harassed. And so what these programs do is it, if you will, hides their physical address, what they're, where they actually live, and it provides a substitute or designated address. And it may apply beyond just their home as well. And Marci will talk a little bit about that later. It is intended to hide their location, and it's, of course, so that the perpetrator doesn't find them and it doesn't harm them. These programs are administered generally by an agency, a state agency, and it can be the Secretary of State in a lot of states or the Attorney's General Office. And these state agencies, they collect the person's correspondence, their mail, and they forward the information in the mail to the participants at their actual addresses. As Danielle commented earlier, these programs are sometimes referred to as safe at home laws or safe at home programs, which is, again, different than the ones that we're subject to now, which are more like lockdown orders. This type of program was developed, it started in the state of Washington in 1991. And it really, before that, there was piecemeal legislation and piecemeal tools out there for persons to protect their identity in the event that they are victims. And it allowed them to suppress their information, but only in certain records. It was very clunky, it's burdensome, and quite frankly, quite difficult for people to navigate. And so then you saw the advent of these programs coming about, and now there are 40 states that have them, including DC. And there are other states that are looking at adopting them as well. So they are growing in their popularity, and many are evolving. So they may have started with some basic structure, but they're getting to be more and more complex. A good example of that is in 4 of the states, there are requirements for businesses to accept the substitute address. They can't ask for their actual address, and there are prohibitions on sharing that address if they were to get the goal. They're sharing the participant's address with any other parties. Those states are Minnesota, Iowa, actually I said 4 states, it's 5, because Indiana just came on board. Minnesota, Iowa, Wisconsin, Maryland, and Indiana. And so it's really important, and Marci will talk a little bit about them, these laws vary among the states. So there's not one uniform version statute out there, and you've got to look at each of the states. Marci?
Yeah, that's right, Patty. So for these 5 states that require a non-public or non-governmental agency to accept the substitute address, that is really intended to bolster the protection of the ACP. So for states that don't require a business to accept the substitute address, there is a lot of potential for the abusers to get their hands on the victim's real address, because it will, of course, be more out in the public. So as Patty mentioned, this is typically run by a state agency, and the way that it works is that the state agency, whether that is an AG's office or a Secretary of State's office, is typically the hub of the program, but they will use other local agencies and community groups to act as program assistants. And so if you go to any of these Safe at Home websites and you click around, you'll see that there are several program assistants throughout each of these states. So it's really pretty pervasive in these states, and allows victims pretty ready access to the program if they're knowledgeable about it. Now, while we don't know exactly how each program works in all of the states, I had the opportunity to talk with the administrator of Wisconsin's program. Patty had the opportunity to talk to the administrator of Iowa's program. And one thing that I was told from the Wisconsin administrator is that at the very beginning, the program assistants will meet with the program participants and work with the participant to develop a safety plan, basically to ensure that the participant will act in conformity with the program to keep her or himself and their children safe. So while there are certainly obligations imposed on state and local agencies, as well as private businesses in these 5 particular states, there's also, of course, some obligations imposed on the victim.
So if you think about it, it's similar to the DPPA, and that's the Driver's Protection Privacy Act. It was enacted years ago by the federal government, and you may recall it was in response to a movie star being murdered by a stalker who got her information from the DMV pretty easily. There were days where you could just call the DMV up and give them a license plate, and they would give you all kinds of information. So it was enacted to prevent the misuse of DMV. So if you think about the DPPA, it didn't cut off the ability to obtain DMV data, but it did limit who, when, and how that data could be inserted. So it built in privacy rules around that data. And that's similar to what's happening here in an ACP. There is access to the person. We're not trying to cut that person off, or at least the program isn't intended to cut that the person off from, everyone else. But what it is to safeguard their location for obvious reasons. And so the participant uses that address that they get, the designated address, the substitute address. Different states call it different things. And they use it for various things. So for instance, they'll get a driver's license in it. They'll get their state identification card if they don't have a driver's license. They'll use it for all their, utilities and anywhere where they're providing. And again, as Marci said, states vary on this, so it can be a little bit different. Some states allow for some of, like a utility company. Iowa, I think, is one where it allows the utility company to get the real address because they need it, obviously, to provide the service. But other than that, they use the designated address. It's also used for voting purposes so that the person isn't in the voting, the rolls that are out there that are also public information. A program participant is, in most states, they have what's known as an authorization or a program card. And so it'll have a description on the back, at least in Iowa, it has a description of the program and why it's in place, and, and the contact information for the agency that administers it, has the person's address, their substitute address. And people that are participating in the program can share that card, that provide their address, and for proof of their participation in that ACP. A lot of states will have a process by which you can verify the participant's participation in the program. And Iowa, again, is another example of that, where you can call them and they can verify it. They won't give you their address, they won't tell you where they are, but they'll verify that they're a part of that program.
Yeah, Patty, and just going back to what you were saying, that it's not really to, cut the person off. It's certainly not like a witness protection program, right? It's more of another tool that a victim can use to keep the victim safe and to keep the victim's children safe. And I also just wanted to comment on the DPPA. This is an example of the kind of piecemeal legislation you referenced earlier that was in effect before ACPs were implemented. So statutes like DPPA existed, but they were more along the lines of suppression of that information in certain public records. But before the ACPs, there was no ability for a victim to use a substitute address. And that's really, I think, a key difference between the suppression type statutes and the ACPs.
Right.
So, yeah. So that's a general overview of it. We're going to step more closely into some of the statutes. But one quick comment, this is, of course, a really great and noble effort to protect victims of violence. But there are, as Danielle mentioned, certainly collateral issues that arise as a result of these programs, including issues that affect your daily lending operations. So that's what we'll be discussing today. To set the stage, we'll start by reviewing the language of a couple of these statutes that require businesses to accept the person's substitute address. And then we'll do some issue spotting and origination and servicing, and discuss what are some ways to ensure your company is complying with these programs. We certainly don't know all the answers here, but our goal is that we hope that our discussion will give your companies the ability really to assess and implement policies and procedures to address the program.
Yeah, and to follow up on that, these laws are going to be intimidating. They're going to feel like they're troublesome, and they are going to impose an additional amount of burden. But it is very possible for companies to have a protocol to deal with it, and you want to have that in place now before you really encounter the situation, and for obvious reasons that we'll talk about in a little bit. One thing to think about, the agencies that administer this, they're not trying to hide these people. Like Marci said, it's not a witness protection program. They're not trying to hamper and trying to not have these people pay their debts. They're actually quite cooperative and collaborative. They very much want to work with industry, and in connection with developing their statutes and rolling them out. A lot of them did reach out to stakeholders out there. I know Iowa, for instance, reached out to the state bar in Iowa. They've and I've been talking to the administrator. She's actually going to be doing a presentation to the Iowa Bankers Association this coming summer. So they definitely have a cooperative spirit and incentive. They don't have, depending upon the maturity of the program, as far as how many types of situations they've dealt with. So, for instance, in Iowa, I called and I talked to them about, a motor vehicle repossession scenario and how they would handle it. They hadn't handled one yet, but she was very cooperative, and she said, this is probably how we'd do it. We'd work with the creditor X, Y, Z, and I'll talk a little bit more about that later. So one thing that, we'd recommend for companies is, especially if you have like a small footprint, even a bigger one, is start contacting or getting in touch with the administrators and work with them and talk about the practical issues that you're going to have that relate to these programs, because they're very much willing to work with you. And as part of the materials that we forwarded to Marci Berger for the program, there's a list, a little bit dated, but there is a list of states that have the program and who the contact person is there. So that is definitely a starting place, and you can, of course, update that. All right, so let's go on to the next slide, and let's talk about some of these programs as Marci spoke that we would do. Because this is new, we thought it would be helpful to actually bring the statute up and put it in front of you so you could look through it. So this is the Iowa Confidentiality Law, and this identifies that there is going to be the use of the designated address for service or process. Let me back up. I think I skipped a slide. There we go. And so initially, the program participant is given this address, and persons are required to accept that address from the program participant when they're required to submit it. The only time when they're required to provide their actual address, or there's an exception, is that if it's impossible to provide that service or that benefit without knowledge of the participant's physical location. And that goes back to the example I had with the Iowa's, the utility company, where you can't provide, the light service, you can't provide water service or whatever, electrical service, unless you know the physical location. But those companies are then prohibited. All correspondence has to be going to the substitute address. They can only get that information for purposes of actually visiting to provide the service. Here is where it provides for the service of process and how that you use the designated address for the service of process. And I'm going to go through these pretty quickly. You'll have these slides so you can actually read through the statutes a little bit more in depth, but we did want to point some of this out now here. On this slide, it's an example of Iowa where there is a prohibition on disclosing the participant's address unless you've got an exception. And one of those exceptions is if you get written consent of the program participant. And note that under that, which is highlighted in italicized or bold in italicized, is that it doesn't in Iowa apply to real estate, to real property. So the states differ on that, and Iowa's does not protect or doesn't apply to documents or records that relate to real property.
Okay, thanks, Pat. So in Wisconsin, like Iowa, may use the substitute address for all purposes. So this would include, of course, taking out a loan or financing the purchase of a product. Further, no person who has received a notification form from a participant may refuse to use the assigned address for the program participant, may require a program participant to disclose his or her actual address, or may intentionally disclose to another person the actual address of a program participant. This is pretty broad. In other words, as we say to our kids on a regular basis, no ifs, ands, or buts about it. Notably, there is no exception like there is in Iowa, where a person may condition the service or benefit on receiving the actual address because it would otherwise be impossible to provide the service or benefit without that address. So a few of the definitions: actual address can include not only a residential street address, but also your school address or your work address. And the actual address is the address to which the DOJ will forward mail to the program participant. Interestingly and notably, DOJ will not accept all mail. It will not accept those Amazon packages or magazines, for example. And because the law prohibits the participant from disclosing his or her physical address to the abuser, to be safe, this really must mean that to get mail that the DOJ will not accept, the participant will have to have probably another PO box of some sort to receive mail that the AG will not accept.
And interestingly, when I talked to the Iowa Secretary of State, they will give, as Marci says, that this is just one element of trying to keep these folks safe. And so they have some tips that they provide to participants as far as how to deal with packages, like having them sent to your employer, to a friend, having it sent if you're buying something online, having it sent to the store and picking it up at the store. So in those states where they don't allow for packages because they're worried about some kind of a tracking device or some type of a harmful thing like an explosive to be sent via the packages, they do try to help the participant manage, how am I going to get my packages?
Yeah, that makes sense, Patty. So further, under Wisconsin law, like Iowa, the department can't disclose the participant's actual address unless they're ordered to do so by a court order. And then in that case, the AG must request that the file containing the person's actual address be sealed and remain confidential. I don't have it on this slide, but in Wisconsin and in other states, personal service must be made on the AG's office. It cannot be made on the substitute address. So that's something to keep in mind if you're dealing with a participant and you're trying to commence a collection action, for example. Under Wisconsin law, there's no private cause of action, and indeed, the laws that I reviewed, and Patty, jump in if you saw something different, there really is no private cause of action related to these statutes, but there are often criminal penalties associated for intentional disclosure of the actual address of the program participant.
That was similarly, I didn't see any causes of action either.
Great. So that's a little summary of Wisconsin. And Patty, I think you want to point out a couple things on Minnesota.
Yeah, so Minnesota, actually Iowa's was modeled on Minnesota, so it's really similar. And in this slide, you'll see that the program participant cannot be required to provide their physical address. And then here you see that, again, anyone who receives or is interacting with the program participant cannot disclose, and they receive the program participant's information, they can't disclose. And I mentioned earlier that it could be beyond the home address. And here's a good example of where it's the home address, the work address, or the school address. And the only way that those can be disclosed is if there is written consent from the participant, from the consumer. There's the requirement here, you'll see in the italicized bold, that you have to accept that designated address as a true address. And we got a question that came through as to, what is that substitute address? We'll talk a little bit more about it, but it's generally a PO box. Iowa does have a street address that is included, and we'll talk a little bit about that in a minute. And the program participant can't be required. They can refuse to tell a person who is inquiring as to why they're included in that program. It's interesting that Minnesota does provide the timing for when that mail is going to be forwarded, and in Minnesota it has to be forwarded at least every second business day. So that I thought was pretty interesting. A lot of the others that I've seen don't have a timing requirement necessarily in the statute. Minnesota does have an exemption for complying with federal law, and so that's I think pretty interesting and can be helpful to financial institutions. This is not something I typically saw in others, but Minnesota does have this. And it also has an exception or at least a limited use of the information for those services that are tied to the residency or have to be delivered to the residency. And again, this is something that a financial institution in some instances may be able to avail themselves about, but you want to be really careful that this is maybe just limited to Minnesota, and you'll want to definitely look and track the statute with respect to that. There are going to be circumstances here where you can actually use it, but there are going to be limitations as far as the reuse of that information as well.
Thanks, Patty, and I'll agree that I didn't see anything in any of the statutes that I reviewed that provided an exception for compliance with federal law. That's very interesting and important too. I'm going to talk just a little bit about Maryland. Maryland, in Minnesota, and I believe Iowa too, although no, I think just Minnesota has real estate shield provision, which basically means that the address of a person's home would not be reported in real estate records. Maryland does not have that. And neither does Wisconsin. So in Wisconsin, one thing they do is when a person is a program participant before they own a home and then they wish to buy a home, the Wisconsin AG's office will work with the person to try to set up a trust to purchase that home. So then they shield the person's actual address from real estate records by creating that trust, and then the person's actual address is not out there. And lenders in the past, anecdotally, have helped participants create that trust. But when it is not offered by the lender, that is a costly approach. All right, so a couple points further about Maryland. Like Iowa, a person can refuse to provide a service or benefit if it would be impossible to provide that service or benefit without knowledge of the participant's actual address. We'll talk about this in a little bit, but when would it be impossible to provide a service or benefit in the situations that you all will be confronting? Another quick point, as noted on this slide, is that as part of an application into the program, the participant waives any claim against the state except for claims based on gross negligence. And notably, there's no such corollary waiver for non-state entities. And that is a perfect segue. Let's get through all these Maryland slides, but you can review at your leisure. That brings us to a real case, which shows that there could be some high stakes here. Let me tell you about one case we came across while researching this. In Minnesota, which, as a reminder, has the real estate property shield provision, a participant filed a lawsuit against the bank, complaining that the bank did not follow Minnesota's ACP requirements and disclosed her new home address to others. In that complaint, the plaintiff alleged she received mail to her home address from the bank, and she also received non-bank mail that clearly knew she was a new homeowner. So this plaintiff alleged that she inferred from this correspondence that this meant that the bank had shared her new home address with others. As we've talked about, and including under Minnesota law, there is no private right of action, but the plaintiff alleged breach of contract, unjust enrichment, invasion of privacy, and negligence. And in the complaint, she sought a judgment in an amount more than $50,000. So what happened here? We don't know. The complaint was ultimately dismissed by the parties, but the media did report that a settlement occurred between the two. Certainly, these issues can happen, and here it showcases why it is important to understand ACP requirements in the states in which you're operating and undertake efforts to comply with those requirements. Notably, the bank in this case, Wells Fargo, has adopted an address confidentiality program that we came across online. And in doing a little bit more research online, we could not find any other similarly situated banks with such a program.
All right, so let's now talk about some of the operational and compliance challenges that we're going to have. And they're going to start at origination. And so we might have a situation where someone wants to make a secured loan. And it's obvious that you're going to need to know the location of that collateral. And that collateral could be real estate. And as Marci talked about before, some states shield that information, other states do not shield that information. In some states that information can be shared, in other states they can't. It could be a vehicle, it could be a refrigerator, it could be lots of different things that could be securing that. And how what do? Do you get a promise from the customer that they'll deliver the collateral if there's an event of default? Do you work with a state administrator on a protocol to have to deal with that repossession if you need to take possession of that? You get a court order. And really any one of these could apply. It really depends upon the state in which you're located. As I mentioned, I talked to Iowa about this scenario with respect to vehicles and repossession, and they said they hadn't dealt with the issue yet, but they would work with the creditor. And so what they would envision is having an agreement with the participant that's buying it and the creditor that in the event that there is a default, that the administrator would then contact the customer and have the customer then arrange for a voluntary repossession. So it is something.
And Patty, that is the exact solution that Wisconsin has adopted. In fact, there has been some situations there that have arisen, and in those cases, or what they do on a now go forward basis, is that up front, they agree that the borrower can give the lender the AG's contact information in the event that the borrower participant defaults and the lender wants to take the collateral. I understand from the AG's office that in the couple of instances where the borrower did ultimately default, and the lender informed the DOJ that it was trying to get that property, the DOJ intervened and informed the borrower, look, you have to make arrangements to get this collateral back, or you're at a real risk that the lender will get a court order requiring the agency to disclose that address. And in each of those instances, that was enough, and the customer cooperated with the lender to return the collateral. So, I mean, of course, stating the obvious here, having to get a court order is more expensive, but given that the state AG or other administrator might be involved, it seems that the consumer is more likely to cooperate.
And I would echo that. And also, at least in Iowa and some other states that I saw, the program, the participant can be expelled from the program and terminated. So they can be essentially pushed out of it. And that's going to be an instance where they're not cooperating with the state agency. I think that's a great example of where the program could be terminated for that particular participant because they're not willing to work with the administrator in connection with a legal debt. And I know, for instance, also in Iowa, they said that if the person refuses service of process, they would be terminated from the program. So this isn't, again, something to shield the person from paying their debts and from interacting as any other person would, but it just protecting them from being located by the perpetrator.
Yeah, exactly.
I think you're going to talk about.
Do you think in Iowa you could take the position that you can't provide the product or service without the loan agreement being secured? And that you need
okay. Yeah, I don't know. I think that there's a stronger argument, although real estate can't, because they've already clearly addressed real estate and that they've said that it doesn't apply in a real property context. I don't know that you can make the argument that that you can't provide it because you can, that your collateral is what's really affecting the pricing of that loan, and potentially that I guess you could make the argument that we wouldn't make a loan at all unless we got the security interest in the collateral. And so since we wouldn't do it at all, we would decline the person. It's impossible to provide that product or service. But that's hardly fail-safe. I think it's risky. I think it's, it's definitely not something that we've seen before. And it is something that, an institution has to think about whether or not they want to take that risk. There's the alternative thing of, do you really want to decline somebody that's creditworthy? There's, if they're purchasing goods, like for instance, and if they're purchasing a vehicle, that's not really a service or a benefit. But then again, the financing that you're providing, that is a service in connection with the purchase of that good. So it's a square peg, round hole type of a situation.
Yeah, I agree. And I think while a lender could take that position, it could certainly subject that lender to regulator scrutiny at a minimum, and maybe even some reputational risk. In Maryland, I'll note that a state or local agency can request a waiver from the requirements of the ACP if it has a quote unquote bona fide statutory or administrative requirement for needing that actual address. But there's no, so in other words, a state agency can obtain some certainty that it doesn't have to comply with the program by applying for and obtaining that waiver. But there's no similar option in the state for a private entity to seek that waiver. And so to your point, the lender, if they chose that course of refusing to provide, would just have to hope that its argument that it's impossible to provide that service or benefit would withstand judicial or regulator scrutiny if any questions were raised about it. Another question that, Patty and I discussed is, what if the creditor has a policy that simply does not allow for credit to be extended unless a physical address is provided? So, for example, under the creditor's policy, a PO box is not permissible as a substitution for a physical address. Would that mean, do you think, in Iowa and Maryland, it's quote unquote impossible to provide that benefit or service, i.e. the financing? Again, it's really a risk issue.
Yeah, I'd agree with you on that because it's your policy. So as far as impossible, maybe because that's your policy and you apply it across the board to all persons. So I think it is something where that, arguably it's impossible to provide it, but again, it's not fail-safe. As I mentioned earlier, the substitute address in most states is the PO box. There are some states, Iowa's an example, where they do have a street address that they provide, but it's a fictitious street address. So in Iowa, it's either the middle of a river if you were to try to map it out, and other states may have that as well. One thing that I found really interesting is that this information, which I think we'll talk about later, how it's really helpful, is published. And so the regulators, as I mentioned, as a supplement to the presentation, we've got material with contact information for those state agencies. They'll provide you with those addresses so that you can get those addresses and you'll know what those addresses are beforehand, and maybe build a database with that information that might be helpful. One thing to think about is, is that kind of a policy? Is that going to violate ECOA and Reg B? Well, as far as I know, address is not a prohibited basis. So I don't think that that's a if you will, disparate treatment. But then there could be disparate impact, which means you need to go through that 3-step process of determining whether or not there is a disparate impact and whether your company has a legitimate business justification for that policy. And that, I think, is going to depend upon the type of credit that's extended. Because if it's secured credit, particularly real estate, maybe so, and for vehicles, but then if it's unsecured credit, I don't know that there is a legitimate business justification for requiring the person to provide their actual physical location. There's collection purposes, being able to collect on that debt. As Marci pointed out earlier, these are business risk issues that companies need to think about to work through and to determine, where they're going to essentially fall on that issue, what their final policy is. What I'd recommend is, as you go through that process, is, it's kind of like do your math homework. You couldn't just provide the answer; you had to show your work. Here, this is going to be an example where you want to show your work. What are the things that you considered when you came up with that legitimate business justification? Because if you're ever challenged about it, you're going to have a bench of information where you can, rely on. You can say, yep, we thought about it at the beginning, and this is why we ended up at this policy. And we thought about alternative means or alternative policies, and they just didn't achieve our business requirements here. So this is why we landed here. But it's going to depend on the states too.
Yeah, and maybe it's too infrequent really to worry about. As we were talking to folks on the ground, we learned in Iowa that there's about 600 participants, Wisconsin around 1,100, and Maryland too is right around 1,100. Given those numbers, maybe it's too infrequent to worry about.
It is. I mean, that's definitely something to consider. When I asked Minnesota, theirs was at 3,500, so a little bit more. But the thing you think about is reputational risk. Do you want to be known as that company that did that, especially if there is a really terrible outcome? You want to be that company that's on the front page of a paper and to be associated with that. So that's something to think about. The other thing you have to think about is state law, because some states have anti-discrimination statutes as well. And Illinois, for instance, they do actually prohibit discrimination based on a consumer being the subject of an order that's under their Illinois Domestic Violence Act of 1986 or in another state's court order. So if a person has a protective order in Illinois, whether it's Illinois or under another state, you can't discriminate against them in a credit transaction. So that's a good example of a state where it would be problematic if you discriminated based on their participation in this program, and maybe that's where you end up with the policy of only requiring that PO box. So you would have to make an exception for someone that is in the program. So the questions and the issues continue. So, which I've just kind of alluded to is, whether you have to require that PO box. Interestingly, states do have a validation mechanism. So if a person provides that PO box, and I kind of goes back to my recommendation that maybe you put together a database of these PO box that you can ping, when you're going through that credit app process to see if the person's PO box or their address matches up with one of these state designated or substitute addresses, because then if it does, the person is participating in this program and you can flag that account. And as Marci mentioned, the address is confidential, but the fact that they are participating in the program is not confidential. So you can call the Secretary of State or the DOJ, whoever's administering it, and ask, is this person participating in the program? And generally speaking, they'll validate their participation. They won't tell you where they live or the county or anything like that, but they'll validate their participation in the program. So that's one way you can mitigate your risk with having that type of a policy, if you have one, where you do not accept PO box addresses. You can make an exception here, or if you do accept them where you can mitigate your risk as far as who you're lending to or who you're extending credit to. And there are going to be downstream sharing issues. We talked a little bit about repossession and a scenario where you might have a repossession, but once you have that repossession context, can you share the information with a repossession company? Can you share it with a service provider that's doing something else in connection with your account? Some states it's going to be permissible. Go ahead.
And I think we should even take one step back, right? So can a creditor require the customer to provide his or her consent to disclosure of address to a repo agent or other service provider to be eligible for that credit? And I think we had a question from the audience that was similar to that. And in some states, I think it might be permissible to do that, but it's probably unlikely in states where there's a prohibition on disclosing the address information. Like in Wisconsin, as I said, no ifs, ands, or buts about it. You can't disclose it. But in Maryland, a lender could ask for that information and obtain consent from the customer to share that with the repossession agent. But there are some obligations imposed on the lender in doing that. The lender must limit the disclosure only to that necessary for the purpose, which would be, of course, repossession of the vehicle. The lender sort of has to act as the caretaker of that information and tell the person to whom it's disclosing, the repo agent, that the person is involved in the program, and the participant's substitute address must be used for mail correspondence, so that actual address can't be used. And then another point under Maryland law, if you obtain such a consent, you need to obtain an extra consent before you include that actual information in any of your internal records or electronic databases that might be transferred or shared downstream with third parties. So at least in Maryland, there certainly is a workaround, but if you get consent to share with the third party repossession contractor, you really should be getting some sort of agreement from that vendor that they'll comply with ACP requirements, and even think about obtaining some sort of specific indemnification for that if the third party contractor discloses that information and you're caught in some sort of lawsuit. And perhaps your dealer agreement already covers that. The indemnification provision is broad enough to cover that, but that's the things that you should be thinking through if you do get your hands on a physical actual address and you're able to share that with a repossession agent or another service provider.
Those are excellent points, Marci. You're exactly right. You've got to kind of step back, and that's really for all of these topics. You need to really think through from the beginning. Can you get the information? If you have the information, can you share that information? How do you share that information? Do you need to work with the administrator? So there are lots of steps in the process of thinking through that. And then there are other origination issues like, what if you have stipulation, you're an indirect finance company, and you have stipulations that have to be satisfied in order to extend credit when you're working with a dealer. In a lot of instances, that may kind of self-resolve because the person is using that substitute address on all their interactions and all their personal business. So if they've gotten any kind of utility bill or telephone bill or whatever, those companies are going to be required to use that substitute address. So they'll have correspondence. They'll have, if you will, proof of residence addresses or proof of address information that they can share. It'll be potentially a PO box, but they can provide that type of support.
Yeah, that's an excellent point, Patty, and it reminded me to talk about references. Should a creditor be collecting references at origination, and could that somehow jeopardize the confidentiality of the participant's address, him or herself? Think about it. A reference very easily could live with the participant, but that reference is not in the program, so it's not protected information. So again, a question to which we don't have the answer necessarily, but the things to sort of be thinking through when you're obtaining references. Maybe when somebody is involved in the program, you only obtain the phone numbers of the references rather than addresses and phone numbers. Another topic is underwriting. So owning a home is often a metric used by finance companies to determine creditworthiness. If a finance company can't use that information, can't be made aware that this person owns a home, that may affect the pricing of the loan. And so what is a possible solution here? Do you offer a higher APR or maybe a larger prepaid finance charge to price out that perhaps increased or diminished creditworthiness? Or perhaps try confirming with the state administrator that the program participant owns a home. So those are some of the things that you might want to consider if you use owning a home as a metric to determine creditworthiness.
Right, and then there's federal law requirements that we have, like the FCRA's address discrepancy requirements, and that's an instance where when an application is submitted and it contains an address, if it doesn't match with the address on file for the person at the Consumer Reporting Agency, the Consumer Reporting Agency is supposed to provide notice to the user of the report, and then that user of the report has to confirm that the person that made that application is truly the person that is subject of that consumer report. So essentially validate that the consumer's identity and determine whether or not there's, rule out, if you will, that there is identity theft. And so if you think about it, these people that participate in these programs, they're going to feel like they they don't want anybody inspecting or doing further due diligence on them, because they're kind of fearful that their information is going to be disclosed. And so it kind of puts a weird situation there, as far as the creditor has to confirm the identity, but the person's going to feel like, I'm feeling like someone's trying to out me here from my program and disclose my information. And that goes back to that database that I was talking about. Potentially, it's kind of like, the death, the social security number for persons who have passed, and other fraud databases that are out there that you ping them against and this kind of comes up later in that last bullet, when I talk about red flags, that you can ping to see if the person is a part of one of these, or is using an address that's on one of these, if you will, blacklists and such. And so you can do that with respect to the address discrepancy, because if you do, you can say, oh, this is one of the state agencies, or one of these ACP program substitute addresses, and they've provided this other proof of identity. So I've gotten comfortable that, the address it's not identity theft involved. There's a second part of that rule, which is a user that if the customer is a consumer, they regularly furnish information to the CRAs, and if they later discover an address that's not on file as the consumer report, they have to then report that information. And so, query, if you have information that doesn't match what's in the consumer reporting agency, or consumer reporting agencies aren't required to redact this information, there's no, I talked to someone about this, and there's no requirement on consumer reporting agencies with respect to these types of programs. And so do you report this to the consumer reporting agency? Do you not? So these are things you have to kind of weigh out as to whether or not you ought to or not. Of course, federal law is requiring it. Other things to note, that the consumer report may have other addresses on file for these persons in their consumer report. Do you use that information? Do you not use that information? Can you use it for skip tracing purposes? The FCRA, as we know, is really the first federal privacy law out there. So there are limitations on who can obtain that information. You have to have a permissible purpose. There's the disposal rule that requires, the handling of that and the disposing of the information. And then there are record retention requirements under ECOA that you have to think about, the 25 months. So those consumer reports have to be maintained. So there are a lot of elements that need to be thought through when you're thinking about the FCRA and the address information that you may obtain from the consumer. And there are more federal laws, right, Marci?
Yes, there are. And I just want to bear in mind the time here. So I'm just going to quickly go through the BSA. So under the Bank Secrecy Act, financial institutions have to have a customer identification program. These CIP requirements are generally not applicable to finance companies, but they are to financial institutions. Luckily, we have some clarity here. The FinCEN issued a letter ruling addressing this issue, and basically it allows a financial institution to collect the street address of the ACP's sponsoring agency, so the AG or the Secretary of State, for purposes of meeting the financial institution's CIP address requirement. And then passing it back to you, Patty, on red flags.
Yep, I mentioned red flags, and I'll briefly go through that. So, if you have a red flag appear under your identity theft prevention program, you've got to confirm the consumer's identity. The database I talked about is one solution. Also, as I mentioned with the STIPs, the person's going to use that address on all their personal correspondence and their personal business. So you may be able to do so with getting additional proofs of the address. Right, so now we're going to move on to servicing.
Yes, thanks, Patty. So at its barest, ACPs are privacy statutes. So those on this call are very familiar with the GLBA and the requirement that you provide a privacy notice to a customer or consumer whose PII may be disclosed by the lender. Generally, through a privacy notice, the consumer gives broad permission to you to disclose his or her PII, which would include the consumer's address, of course. It may be your normal business practice, and again, it's consistent with your privacy notice, to share or sell that PII to affiliates and non-affiliates. Once that disclosure happens, it's virtually impossible to put the cat back in the bag. The information will be quickly disseminated online into web pages like White Pages, Tokyo, etc. So even though you may give the GLBA privacy notice, and under the GLBA privacy notice, you may be able to share PII consistent with that privacy notice, really that does not preempt your requirement to comply with the ACP privacy requirements and not disclose that address information if you have it.
Yep, and so in the interest of time, we want to definitely leave time for questions. I'll just mention, GPS, it's going to come up in those scenarios. There's going to be a delay in correspondence. There are IT and authentication tools out there that we're using for cybersecurity. Skip tracing is an issue. There's going to be, how do you handle address changes? So there's lots of servicing issues that come up. We've identified them here so you can consider them. But let's make sure that we have enough time, Danielle, for questions for folks, and we're happy to answer any.
Thanks so much, you guys. That was amazing. So some of the questions you've maybe addressed in part. I think in the interest of time, I'm going to ask two at once so you can sort of touch on both, and then I'll kind of skip through that way. So one question that came in early was, is the type of substitute address like a PO box? I think you addressed that, but if you could maybe sum it up again. And then also, and this is the million-dollar question, how does the lien holder repossess a car if we can't give the repo company the place of residence or where they work, et cetera?
So I'll take the first one, and Marci, you can take the second one, or I'm happy to follow you. On the first one, it's the PO box. Some states, as I mentioned, have a fictitious street address just so that the person can use that in an application or whatever. But it is generally going to be that PO box of, and they work with the post office to do this as well. But it's going to be a PO box that's been set up by the Secretary of State or the AG.
Yeah, and then on the repossession question, that's absolutely the correct question, is how do you repossess when you don't know the person's physical address? So in some states, as we mentioned, in Maryland, you could get consent to get that physical address and share it with your repo contractor. That can present some risk because you have obligations to make sure that contractor knows that the person's in the program and shouldn't be using that address for any other purpose other than repossessing it. And then in Wisconsin, and it appears it would be the same process in Iowa, you could ask the borrower to get agreement from the state administrator that on default and efforts to realize the property, you contact the state administrator intervenes and says to the customer, look, you got to turn this over, otherwise we're going to be required to give that information in a court order or under court order.
If there was a scenario where you knew the address, like through, camera programs in states where they've got like license recognition systems, where you knew a likely location of a car without a person's name associated with it, but you know that that's your license plate of your car you need to pick up, if you were totally taking the person's name out of it and their address, even if it coincided with their address, do you think that would be an issue? I mean, I wonder if that's the only way you could get at it in some of these places.
So essentially, you're doing it based on the car. You got to think about that. Again, we talked a little bit about reputational risk. Mm-hmm. Do you want to be that company that's associated with somebody potentially getting really harmed and being on the front page of a paper? I mean, I think that's one of the guiding principles here. And, the intent is to keep their location secret. And the car is, it's going to go right alongside that person potentially, unless they're buying it from somebody else. So I think it's a little risky. And I think he worked with the administrator. We spoke with two and emailed with a third. But everything I've seen, and I did a fair bit of research, actually a lot of research on this, the administrators want to work with stakeholders to make this work. The intent is not to hide the person from their debts or to make these people not be able to live their lives and have normal personal, business interactions, but it's just to keep them safe. And so I think it's working with those stakeholders and opening a dialogue with them. And that may be something, you could do as a company, and maybe something that, a collaborative a group could do.
Yes.
AFSA, if you may be interested in doing something like that, but I definitely know that they're willing to go out and speak to groups. So we could have one of these administrators come speak and really talk through these difficult issues, because they know these people have real lives to live.
I'm going to let us go 60 seconds over because we're at the top of the hour, but I want to ask these last two questions in 60 seconds with answers. Are lenders allowed to refuse to make a loan with a borrower in the situation? And then to Marci, how do you make a loan secured by real estate in Wisconsin if the address of the real estate's in the protected address program?
So, go ahead, Marci. Go ahead.
In Wisconsin,
there you go.
Once, if the person already owns a home before they enter into the program's likely not going to be beneficial for them. So this would be a situation where the person comes in after they've been part of the program and they've purchased a home. Hopefully that person has purchased a home using a trust, and they can show you that information that the home is owned by a trust, and give some corroborating evidence that the customer owns that trust or is the trustee of the trust. And that might be sufficient under your policies and procedures to confirm that home ownership and that the loan can be secured by the home. Sorry, I probably went over 60 seconds.
No, that's good. Okay, and then last question.
Yep. Yeah, the refusing the loan, you've got to think about disparate impact. You got to think about state law. You have to think about, do you have a policy in place, and is that policy based on a non-prohibited basis? So it's based on the fact that they're giving you a PO box. So you really have to be careful about how you draft a policy that would essentially have the effect of not making a loan to these people. It's not a protected class that they're, in an ACP program, but, does it have a disparate impact? We talked a little bit about that earlier. And so those are the things you need to consider.
These are such great questions and answers to this really tough issue. We appreciate the way you dealt with it, frankly, but sensitively. And it's, more to follow on these. I think we'll see more of them maybe once we get past the pandemic stuff in front of us. Thank you so much for your time. Marci Berger, is there anything else we need to do to wrap up?
Thank you so much to Marci, Patty, Hudson Cook, and Husch Blackwell. Just remember, the slides and recording will be available on AFSA's website under the Webinar Resource Center. Thank you so much.
Thanks, everybody.
Everyone,
thank you.
Take care.
Bye.
Bye.